right. Welcome, everybody, to our final industry update of 2024. Hard to believe. Here we are approaching the end of the year. I want to extend a huge welcome and thank you to Suzanne Leff, who's joining us today as our special guest. Suzanne is an attorney who specializes in HOA law, and we are really excited to hear what she has to say today. It's certainly an ever-changing world. And we certainly deal with HOAs every day in our business, whether we're title or real estate. And it's going to be just really wonderful to get a quick update on what's going on in the world of HOAs and how that's going to impact all of our businesses. So with that, I'll turn it over to you, Suzanne. Thank you for being on today.
Thanks, Jill. Thanks for having me out. Thanks, Damian, too, for including me in this. And I look forward to our discussion today. Thanks for everyone who's here to be a part of this industry update. I'm hoping that I can provide you some perspective from that HOA side of things, because obviously we're all within a real estate industry, but we have some different vantage points that we come at this with. So good to be here. And I wanted to kick things off just talking about 2024 legislation. There's some big stuff to report, some things to keep in mind as you are working with sellers and buyers in common interest communities. And I just want to give you an overview of some of those things. And I think that will lead into other discussion that Damian and I will have about big issues that are impacting HOAs right now. The things that we're seeing in my office on the legal side of things that are really kind of driving what communities are up to at this point. But just to give a bit of background on legislative issues, since 2022, associations have been experiencing some major changes in legislation impacting the way that assessments are collected and the way that covenants are enforced. So those are kind of two big things going on in the HOA arena. HOAs are around to enforce covenants. They collect assessments to do all of the business of the association. Most associations only have assessments as their operating income for their communities. So with some major legislative changes coming primarily out of those Green Valley Ranch stories that many of you probably read about and heard in the headlines, there have been some additional steps placed for communities in the collection of assessments and the enforcement of covenants. So that's something that a lot of associations were already doing, things that the legislature has now mandated for all communities, but we do now have more of a one-size-fits-all approach to assessment collection and covenant enforcement. So communities are working through those changes. What we're seeing primarily is assessment collection has shifted to more of the association and management side of things, with notices of delinquency going out to owners and assessments maybe being placed on repayment plans or payment plans with owners, where they can have up to 18 months to pay amounts that are owed. And that's for any regular assessments and for special assessments. There's that opportunity for owners to have an extended period of time to pay delinquent amounts. And on the covenant enforcement side of things, there's been an imperfect, in my opinion, approach to covenant enforcements applied by the legislature. And I say imperfect because it's so one size fits all. It doesn't account for all the different types of violations that might be happening within a community.
Suzanne, you are so nice the way you put that. I mean, I've told these guys that the legislature hates landlords. Frankly, I think they hate HOAs too, but that's just my opinion. But
well, there's a lot of opinion about HOAs out there. So I do often, I recognize that HOAs are, sometimes viewed in a not so positive light, but I do recognize as well that when you've got properties within communities that owners own and are trying to sell, or people might want to buy, that you want those opportunities to be maintained in the best way possible. And I want to give this perspective from the association side of things that it's more difficult to enforce covenants nowadays. It's more difficult to collect assessments. And those things impact the market. I think it will have an impact on different sales transactions out there. The covenant enforcement piece now requires associations to give 30 days for an owner to correct a violation before any fine can be applied. And at the end of the 30 days, there's a 7-day period for the association to inspect and determine whether or not the violation is continuing. After that inspection period, there's an additional 30 days for correction of the activity. And only at that point can it be turned over to legal counsel for any, demand from an attorney. That's all fine and good. Again, I have a lot of communities, they've followed that kind of process through the years. Nobody's saying, oh, we got to get it to the attorney. We got to rack up the fines. That's not the typical approach that I see with a lot of communities. However, this 30 days to cure doesn't work for all types of violations. So we have certain kinds of things that might happen on a recurrent basis, but not continually, that are those types of things are causing problems for communities. There is a
Suzanne,
70,
why don't you give an example of one? I just want, because I think it's important for the brokers to understand, from a perspective of an owner living in the neighborhood, it sounds kind of good. Oh, hey, the HOA can't come pound me for some kind of violation or something, but there's consequences to this. And maybe if you could kind of go through what the HOAs deal with, like the one we talked about the other day, I think would be helpful.
Yeah, and I think I was telling you the other day about a barking dog issue, right? And that was in a condominium community where there's a dog that's barking quite incessantly, and there's a neighbor that's impacted and is seeking assistance from the association to get that dog to start barking and causing this nuisance within the building. And the association recognizes that this is a problem, but can't effectively take enforcement action when the dog might not be barking every single day and might stop at the end of 30 days or stop, on day 15. The owner might present evidence that it's not happening right now, it's been cured, and then it can restart that process for the association, which means that there's a never-ending cycle of how to enforce it. And there, we try to come at these things in a way that's practical and is going to hold up in court if it ever needs to go to court. And this barking dog piece seems to be one that's really hard to catch under the current statutory requirements. However, Damian, I know we talked about the idea that associations are in this predicament in a lot with some things, and it might be the barking dog, it might be an owner who is violating a sign or flag policy that the association has and does it 5 days and then pulls those elements in and says it's cured and then puts them out again a few days later. It's any of those things that happen intermittently that can be big issues. I want to say that there is some opportunity to enforce health and safety violations, and that only requires a 72-hour cure period. But a lot of these other things become more of a cat and mouse game that is difficult for an association to effectively enforce. However, there's a small claims court option for enforcement, and owners have the opportunity to take a neighbor to court in small claims court to enforce these types of things. In some instances, that may be the best avenue for getting some type of enforcement action in place or with a neighbor who is blatantly violating these things, but can't be effectively addressed through the association side of things. So
yeah, and that's where the HOA gets the pressure is an owner that says, hey, you got to do something. This is a covenant violation, expects the HOA to take care of it. And then the HOA's hands are tied because of the new statute. So guys, that's something you can look at when, if you hear your clients concerned about it, is maybe advise them that there might be this small claims action that may be a better resource or a better outcome than trying to have the HOA do it because of this 30-day cure period nonsense that thing that the legislature put in.
Yeah, and I know that can be uncomfortable, asking a neighbor to sue a neighbor. I mean, this is part of where HOAs have been there to assist with these things over the years. But it is an option, and I do have communities that have tried to partner with owners on that because it's a way that they can, assist an owner in getting relief when there's an impact to them directly. So I just want you to understand that landscape of assessments and covenant enforcement and where things are on that front right now. And then I'm just going to give a quick rundown of some of the things that have come up with the legislature this past year so that you have just a bullet point list of things that are issues. There was a bill that sought to regulate community association managers. That did not succeed. We know a few years ago, the governor vetoed legislation that would have extended the regulation of community association managers. But as it stands right now, managers are largely, they're not licensed and they're largely unregulated under state law. So that may come up again in 2025, but in 2024, it was not successful. There's House Bill 24-1091, which has to do with fire hardened building materials. This came out of the Marshall Fire and is a bill that's intended to ensure that owners and associations can use fire hardened building materials primarily in fencing. We know the Marshall Fire traveled along a fence line, and had there been fire hardened materials, that might have been more of a deterrent to that fire. So that's out there. There's the accessory dwelling units provision under the new zoning legislation, and that's House Bill 24-1152. This amends the Colorado Common Interest Ownership Act. There's one little part of that legislation that amends Kiowa to void any covenants that restrict the creation of an accessory dwelling unit on any single unit detached dwelling in certain areas of Colorado. So that's something that we expect to see affecting neighborhoods. It will have different impacts on different communities, but we are now, talking with associations about what that means within certain communities. Couple of other things. There's a new law that relates to landscaping practices in new developments and where any community is re-landscaping certain common elements, and that will disallow the installation of non-functional turf in certain areas. I think it's interesting. It might affect what you see. That curb appeal within certain communities is going to be a little different as defined by state law. So you can look for that in a neighborhood near you. There's a new exemption from the Colorado Common Interest Ownership Act for certain small and limited expense communities. So for any of you that are like in Eastern Douglas County, there are a lot of communities that were formed as more of a limited expense community or without an owners association. See this in Elbert County, El Paso County. Right now, under Senate Bill 24-021, there is a blanket exemption for any commercial community that has 10 or fewer units, any residential community with 20 or fewer units, and a limited expense community that has $400 or less in assessments on an annual basis. And there's some CPI kind of adjustment for that $400, but just know that you may encounter more communities now that are exempt from those Kiowa requirements, which can be good and bad, depending on whether you're trying to access some disclosure information or not. You might not have complete clarity on whether Kiowa applies or not, but there's an opportunity for some additional exemptions based on 2024 legislation. I think those are the big things for now. I just want you to be aware of that general landscape, and then we can jump into some other.
You mentioned the collections thing, which I think is interesting because I just want to point out that, I mean, from my viewpoint, the harder you make it for an HOA to collect from delinquent owners means the more onus that's going to be on the paying owners. So you guys may actually see some changes because of collection policy based on the fact that they can't collect as fast from delinquent owners. Just at least that's kind of been my thought on that. But I know that you have some other stuff to talk about on that issue as well. But it is, to me, that does create some problems because you can't get all your attorney fees back, and you have to wait so long to send somebody to collections, which means the onus is going to be back on all the good citizens in the HOA to essentially subsidize the bad citizens.
Those are good words for what I see with this new legislation. And you're right. It used to be that an owner who was delinquent was responsible for the attorney's fees to collect on those amounts, but that has been changed by law that went into effect in 2024. So there's a way that those fees, if they are incurred, they're going to be borne by the other owners in part. So
which is silliness, but okay, I'm sorry, I didn't mean to interrupt, but to me, that's a major change that I think people need to understand. So
absolutely. Yeah, I want this to be just general knowledge for folks so that you have an understanding of how this all works. And I was going to jump into some other stuff that's affecting communities that's outside of state-specific legislation. I think I saw there was already a question about the Corporate Transparency Act, and that's kind of big news this week, especially for businesses. And Damian, I was telling you that HOA board members need to individually register so that they can then report for the HOA entity under the Corporate Transparency Act, because we have this federal legislation that requires all beneficial owners of entities that are registered with their states.
Let's back up before we get into the HOA stuff, because I will tell you the Corporate Transparency Act, I know everybody's tuned in because you're talking about HOAs and everything, but this has further reach than that as far as it actually applies to a lot bigger swath than just the HOA. So maybe we could talk generally about what the CTA does, and then we can get into the micro of the HOAs kind of thing. So, I mean, do you want to go ahead, or you want me to, or it doesn't matter to me?
Yeah, let's talk about the Corporate Transparency Act and Benson.
I mean, we've had 2 years of learning about this in our education, so.
Right. Yeah. Well, it's meant to prevent fraud and money laundering, and is a federal law that is trying to identify the beneficial owners within various corporate entities around the country. But Damian, you add your.
Yeah, I mean, my flavor is I think it might be an invasion of privacy, but that's beside the point. I mean, guys, we've been dealing with FinCEN and real estate transactions for a long time, because FinCEN has been the ones that have been going to the title companies and saying, hey, if it's an entity or something, we need to know who the beneficial interest is or where the money is coming from, because they're trying to stop that money laundering. I think it's mostly money laundering, isn't it, Suzanne?
It is. Yeah, that's my understanding.
Yeah, mine too. So that's what they're trying to do. Well, they decided to pass this regulation that now says that if you have an entity, which means LLC, company, partnership, or anything else that you hold out. So like for you guys that have rental properties that you have owned in your LLC, or for real estate brokers that are conducting business as a real estate broker, but then assigning their commissions over to their entity for tax purposes, any of those kind of entities now have to register with FinCEN and say who is the beneficial ownership interest, meaning who owns the company. And the purpose of that is to try and get past that first layer and kind of kind of see inside what the entity is doing and who is in control of these and whether they're, I'll call them bad guys, Suzanne, but the bad guys of the, are cartels or money laundering for other purposes or whatever, so that they can kind of pierce into the entities and look at what's going on there. So that's been the requirement that they passed that was supposed to take effect for existing entities that were made prior to January 1st of 2024, that you have to register these entities by the end of this year. And that included HOAs. So I'll let you talk about that. And then you can talk about what happened here this week too. So
Sure. Yeah. So, yeah, I see there's a question about why are HOA board members beneficial owners? Well, the way that this law is written, it defines beneficial owners in a few different ways. And one is where you have that substantial decision-making control. So for an HOA, the board members are the primary decision makers for the entity, and they fall within that definition of a beneficial owner as a result. We've advised our HOA client communities that the board members do need to register because they really are in that driver's seat for their associations as significant decision makers. But there might be other significant decision makers as well. For example, if there's an HOA that has an executive director or general manager who's a staff member who has delegated authority to make decisions, that person will need to register. There might be others who are significant decision makers that need to register, including anyone with a 25% ownership interest in the association. So there might be some of you who have that level of ownership interest in an association. And if that's the case, you may need to register for the association as well, which again, we could have a whole discussion about that.
You could talk, to give an example, if you have a fourplex in which you have an HOA set up around, I think that's the smallest that usually I've ever seen, and you own one unit, you own one unit, you're a 25% beneficial owner, even if you're not on the board. So,
right. Yeah. So it's good to bear in mind, there are penalties for it. For any board member who isn't cooperative and doesn't provide this information, they could have personal liability for that under the CTA. There can be penalties of up to $10,000. There's some prison time that's threatened. Daily penalties of $500 that's adjusted annually for inflation. So that's what we've been dealing with and advising our clients on and saying, get registered, do it. I'm saying I'm not doing it for you because I don't actually have access to the information for all the board members, or when that information changes, there's a requirement to update information with, through this registration process within 30 days of a change in information. So there's no way I can track that for all of the boards and communities. I often don't know who is on the board of an HOA. I don't have all of that specific detail. But
yeah, for some of the lawyers, it's hard. I'm not doing it either. And the reason is because I have no idea when somebody moves, so even if I could keep track of the ownership interest of these entities, somebody moves and all of a sudden there's this requirement that it has to be updated in 30 days. It's a huge liability. And I know there's a lot of third parties out there that are doing this for people. My guess is they have indemnities or something that say that you still have the obligation personally to make sure that you update this stuff, because I just can't imagine anybody wants to take on that risk.
Yeah, that's what I'm seeing. I've got HOA boards that work with management companies. The management companies are using third-party administrators. There's a fee for that. So the associations have to subscribe and pay into that kind of service unless they're going to somehow oversee it on their own. And the third-party providers include indemnification terms when signing up, because the onus really falls on the individual as the beneficial owner to be the person who's providing the information and updating it. So I want you all to know about this, but I know there's a lot in the chat feed right now asking about, what about Texas? There was a preliminary injunction that issued. And
Yeah.
I'm glad this is good. It's like yeah, you've got all the current affairs right here. You're staying on top of the news, and that's great. An injunction issued yesterday out of Texas. So federal court judge in Texas said, this is not, it's enjoined. You don't have to comply with this law right now. And the idea is that there's overreach by the federal government, that this is extending into areas that are not, not within the purview of the federal government. And that will be appealed. We can expect that. But there's also the other side of it is that there might be some legislative change that goes into effect. We don't know. There's a lot that can happen as, this injunction is in place and the litigation continues to go forward. So for right now, people don't have to run out and comply with the Corporate Transparency Act. There is a stay on that requirement, but you do need to, if you're not already registered and haven't already complied, then there will be the need to stay on top of anything that changes and whether that law goes into effect again.
Yeah, the one I read was that there's high expectation that it's going to be appealed. And because, I mean, you and I talked about this, Suzanne, it's a little strange that a district court in Texas can issue an injunction for the entire nation. I mean, that seems like a little bit of an overreach for a district court in West Texas or wherever it was, but
yeah, it makes me wary. I want to cautiously advise clients on this.
Yeah, and then on top of it, if it goes to a court of appeals and they overturn it on December 28th, I mean, it could go into effect immediately, and you just need, I mean, there's a lot of moving parts on this because I mean, the reality from my perspective is I just don't know how they're going to start enforcing this immediately. Just because I think that's unrealistic because people don't really know what the terms and everything are, but you are taking a risk. If they end up turning this over, and you don't hear about it and you don't register, you are taking a risk. And the thing that is scary to me about the Corporate Transparency Act is just the penalties are so severe. It's like RESPA. So
yeah, I agree. What I don't think is that I don't think individual homeowners in communities have access to the information to know whether or not the association or board members have registered. So that gives me a little bit of comfort from my client's perspective, because that could be something that could be used as a sword against HOAs. And I want to be able to advise and get associations into compliance, but also not have it used as another thing against the HOA. So, all right.
Jill, do we have, but before we go on, I think there's some others in here. Let's go ahead and answer these questions real quick, if you don't mind, Suzanne.
Absolutely.
You want to read them, honey?
Sure. I'll just start at the top here. If you go to small claims court for the dog, how do you put a monetary value in order to file?
Oh, so this is not, it doesn't necessarily have a monetary value. You might be able to attach one, but this is similar to what the Texas court did. You would be asking for an injunction against the owner that has the barking dog. So it's an enforcement of a restrictive covenant, which is something that small claims court jurisdiction provides. And it's now more specifically provided under state law. So it doesn't have to be a dollar amount in that case, but you might have some damages that you could assert as well.
Okay, Eric asked, how is an HOA board member a beneficial owner when they do not receive any benefit as a member of the HOA board? For instance, if you have a community of 500 homes, no one has more than 1% to 2% ownership on average.
Yeah, and that's a good question. It's true that the ownership interest is usually low, but it's that substantial decision maker piece that is also defined under the federal law, and that's where the board members are usually in control of most decisions that an association is taking.
What
There's,
legal? Oh, sorry. Go
I
ahead.
was just going to say, there's actually specific guidance on HOA boards under the Corporate Transparency Act and the FAQs that have been issued. This has come up enough that it's out there.
Al asks, what legal remedies does a homeowner have when an HOA doesn't provide the answers needed for an under contract property in a timely fashion? This potentially will terminate the transaction.
Yeah, Damian, do you want to take that?
Well, I mean, the homeowner, I think that's under, don't they have recourse against the HOA for breach of duties or something along those lines? I don't usually do. I usually give that to Miro, Suzanne. So.
Oh, you do? Okay, then, yeah, then Miro writes a letter to my office, and then I advise my client and assist them in complying with the requirement. So there's that, there's that kind of remedy, but there are financial remedies that are available. There are penalties under state law for an association's failure to respond to a records request on a timely basis. So as long as the request has been submitted properly by certified mail and there's an expiration of a 30-day period after that request is submitted and payment has been made for the records, then there can be a penalty that applies. But that's for records requests. It's a little different than those disclosure requirements under your contract. So that's where I don't have a great answer there are associations that simply do not have the documents available for disclosure. And
Yeah,
that's,
and if the buyer terminates, the buyer terminates. I mean, and the seller can only provide what they have. On the plus side, though, the seller isn't in default for not providing stuff they can't get.
so yeah, it's one of those things that I can't adequately say that the HOA industry has fully covered. It's really hit or miss, as you all know from doing the transactions that you do. Some associations have everything in line, and others are scrambling to find documents or produce things.
Eric had a question. He says, I do not believe registration fees are required. You can go to the government website and register there. Sounds like your management company may have hired an outside company to do the registration for your HOA.
That's right, Eric. There are these third-party providers that are assisting with that registration just to help handle this, onslaught of registrations that are required. And anybody can go to the website. There's a FinCEN website that has the registration piece available free of charge. And it's relatively simple. It's fairly straightforward.
Okay, last question for now. Vicky asks, businesses that own and rule the HOA get benefits from having us board members on the HOA. Why then should we not only give our time, talents, but also $300 to help the company?
So
I think
this is
that's obviously a specific question about something. I have no idea what that is, but
it's that registration fee that those third-party providers are charging. I think that's what Vicky's referencing. Yeah.
you could resign.
Right. And I have a number of boards that have come to me with these questions of, do we have to comply? And if so, I'll resign. I would prefer not to give this information. So.
Yeah, that is an option.
Yeah.
Okay, that's all the questions.
Which makes your life
now.
even more difficult, Suzanne.
What do we do when if an HOA is formed and no board exists? How do we handle that? It's a real issue. So, okay, let's. Yeah.
Okay, let's go on to the next one.
All right. Okay, let's talk about another really hot topic that you all may have encountered and has certainly been in the headlines as well. This is insurance coverage for associations. I think it's really important that we talk a little bit about what some of the issues are, what associations are encountering, and how that's going to affect buyers and sellers within communities. What we know is a lot of carriers have left the market in Colorado. They're no longer extending property coverage for communities. And a lot of this hits condominium communities, but that can be planned communities that have attached dwelling units, like townhome communities that aren't formed as condominiums as well, because a lot of the coverage is similar. It's also affecting single family homes with large scale amenities of certain values. So if they hit a certain valuation, that can make coverage more difficult, or if not more difficult, it's certainly more expensive. So this is something that is affecting the operating costs for communities, and associations are seeing significant increases. On the insurance for condos especially, I'm seeing those premiums for coverage go up, 100%, 1,000%. It is excessive in some communities. And the markets are maybe a little bit different in the mountains versus on the Front Range, but it's hitting across the board. There are certain things that some carriers will not insure. So there's this whole list of things to be aware of that might come into play depending on the property that you're working with. Grills on balconies and decks can exclude that property from coverage opportunities in some markets. No updates to plumbing or electrical systems within the last 30 years can be an issue. Electric panels, I'm seeing that as a big issue. There's a scramble to replace panels in some circumstances just to get coverage for the community. Properties that allow short-term rentals can be excluded from coverage. So that's become an issue. Wood-burning fireplaces, that can knock you out of the market for some of the carriers. And then there's this unprotected aluminum wiring that some communities still have in units. And it can be difficult for an association to require just the complete replacement of aluminum wiring. But this conversation is one that I have with clients as well. What do we do? We've got aluminum wiring throughout the project. Now we can't get coverage from any carrier, or if we do, it's 10 times the rate that we've paid in the past. How do we address this? So those are big things as you're working with clients. If you're aware of any of those issues, you might want to have that on your radar, that it could be a problem for insurance coverage. What some communities are doing to address this is they're amending their documents. They're going through a fast track process to amend the insurance provisions of documents to address some of these things, like whether it is, the use of wood burning fireplaces, removal of grills from balconies and decks, doing those types of things, in addition to replacing those components that are uninsurable. So these are high cost items. That it's not cheap to go through the process of replacing certain electric panels. There's a backlog on the supply chain for some of this stuff. It's taking too long to allow for coverage to continue. So that's a real issue. But some communities can shift some of the insurance responsibility from the association to unit owners to reduce the overall property valuation that the association is responsible to insure. And that can help in this really tight market to keep the premiums at a more manageable amount for the associations. So,
yeah, which obviously, if the messaging isn't good, owners are going to feel like the HOA is just dodging their job at that point. So, that's something that I think brokers need to understand. There's a business reason for this, as far as keeping insurance manageable and costs down.
Yeah, and I think, this insurance stuff has been in the headlines just as a carrier and coverage issue, but it has been in the headlines as a specific HOA issue too, where I know there have been communities that have been blaming management or blaming the board for doing something wrong and getting the association into this really difficult spot. It's so much bigger than that. It isn't just a management company, although it's important for all of us within this industry to be aware of what the requirements are so that communities aren't blindsided by the insurance costs when it's time to renew the policy, because often these policies don't, like, the renewal period happens fairly quickly in some circumstances, and that can be too fast for anybody to do anything differently. And it just results in, it might result in a special assessment. And that's what we would like to avoid for communities. But it's a reality. We should just call this industry update ripped from the headlines. All of the news about HOAs that we're seeing out there. So associations can take some steps as long as they're aware of these issues and act proactively. Amending the documents has been extremely effective for some communities that have that option available. But the other thing that, Damian, we talked about, what's it important for owners to understand about this insurance coverage piece so that the proper coverage is obtained. So for any homeowner, if you're living in an HOA and you have some shared insurance responsibility with your neighbors and with the association, it's really important to understand what's the deductible that I might have to contribute towards if there is a hail loss to the project, or if something happens in my home and the association's coverage has a high deductible. So it's really important.
I think even knowing knowing what the deductible is for the HOA, even when you don't have that co-insurance component, is important. Does the HOA have enough reserves to pay the deductible? Because we've seen that come up too.
Yeah, oftentimes associations are not paying the deductible out of operating or out of reserves. That used to be the case more. Sometimes it is the case now, but very often any association deductible ends up getting assessed to the owners. And it gets assessed to the owners with the understanding that many owners have in place what's called loss assessment coverage under their owners' policies. So having loss assessment coverage is key in most communities nowadays, because wind and hail deductibles for condo communities in particular, or townhome communities in planned communities, those wind and hail deductibles are at 5% of the total building valuation, or 8%, or 10%. I mean, they keep ratcheting up that coverage deductible. And that often means that the association is self-insured. It means that there's not going to be coverage that kicks in. So the way that gets paid if there's a wind and hail loss is the association may submit a claim on its policy, but will assess owners for the deductible. And loss assessment coverage under an HO6 or a non-owner occupied policy is going to kick in most cases and cover that. So it's important for owners to be talking with their insurance brokers about this particular issue, but knowing what that deductible is, you got to start there. So getting a certificate of insurance from the association and understanding that particular risk is important.
Which is interesting. If that's what they're doing with special assessments, when's it going to be that the loss assessment insurance starts going up? I mean, you know, that's a consequence that's going to happen once they know that HOAs are treating it as another mechanism for funding their deductibles. It's just going to be a natural progression that now we're going to increase the cost of that.
That's exactly right. It will. And right now, owner coverage is pennies on the dollar to what the associations would have to pay. But we can expect there will be that ongoing shift in business practices, because the carriers don't like to continue paying out on these types of losses. So the other thing to bear in mind on a real estate transaction too is understanding, has there been a recent loss? Has there been a fire? Has there been a flood? Has there been a wind and hail event that has caused a loss that may have been submitted to the association's carrier, but isn't showing up in any of the disclosures? So that might be hard, but if you have a seller who is attentive to what's going on, that could be helpful in identifying it. The main thing is that if there's been a loss, but there hasn't been any type of assessment of the owners, it doesn't mean there won't be. So there's some need to kind of understand what's happening in order to, make people aware of what may happen in the future. There can be some gaps in how that gets covered if a property sold after the loss occurred, but before an assessment was made, depending on
Yeah,
the
and I
carrier.
also see where the minutes are running arrears, and even though there might have been talk about it, a seller may not know anything about it, and the buyer may not be able to find out about it, and that causes all sorts of friction after a transaction
Exactly.
closes. So
I
it's,
often,
buyers should be going to the HOA management companies and having discussions. I think. I mean, Suzanne, do you have any better options for them?
well, here's the thing, if a buyer goes to the HOA management company, a lot of managers won't necessarily tell the buyer what's going on. And there's a lot of like people are skittish about this. Do I disclose something? Do I not disclose something? I try to tell boards and managers that we need to get notice out early and often on these types of things so that there's not that disparate information. It's not something that you have to hold until it's been formally announced. I want associations to provide this as much information as possible to put people on alert to a possibility. But it's not
You
it
don't
doesn't always
you don't
occur
represent
in the
all the
same way.
associations? You don't
I
represent them
don't,
all, Suzanne?
I don't, but I do think there's some similarities in how these things are addressed. There's also, I have a lot of clients that they may have had a loss and it hasn't come to me yet. So I don't know that it's occurred. So I can't even advise on those things. But yeah, this is just part of that landscape of HOAs.
You want to cover
Are
some of these questions real quick? I think some of them were kind of in this vein. So go ahead, honey.
Okay. Melissa asks, do you know if there is any proposed legislature in the works to not allow insurance companies to deny or drop coverage due to it being a high risk area?
So, Melissa, I don't know exactly what might be in the works. I do know one piece of legislation that I didn't discuss earlier that came out of the 2024 session was an insurance study bill. So there is a study that is supposed to occur to help identify what may or may not benefit communities and how this might operate. I'm not sure what to predict. Maybe we'll see something in 2025 because there has been, ongoing insurance stuff going on. But because there's that insurance study bill in place, legislators might hold those types of bills until there's more information about what's impacting the market, what's driving these things, what might be most useful in terms of legislation. So it's a great question, and we'll definitely be looking at that going into 2025 for all of our communities.
Leslie asked or says, our HOA is ignoring the new fire hardened building materials regarding fencing and are still requiring wood fencing as stated in the original covenants. Many of the residents prefer to use the new metal fencing due to fire safety, but are being ignored by the HOA. What can be done?
Well, sometimes associations need education. Not everybody is up to date on what the new laws are. And you may have already brought this to the board's attention. You may have already run it up the ladder through management and to the attorney. If you haven't, though, I would, and even if you have, I think keep pressing on that piece of it and letting people know that there is a law. It's under the public policy provisions of Kiowa that says that you can't prohibit the use of fire hardened materials and in fencing in particular. So I would suggest get a copy of that that particular part of the law. Maybe Damian, it's under 106.5
I was going to
of
look up the
Kiowa.
bill. The
Yeah.
bill is 24-1091. So Leslie, if you go to the legislature's website, there's a bill digest as well as a copy of all the bills that passed in 24. And you could just take the whole bill to them and then highlight the portion that's applicable that changes Kiowa. That might be the easiest way to do it.
Yeah, that can be, I mean, I know you want your boards, you want your managers to know the law, but not everybody knows everything all the time, and education can be really helpful. I had this, I was on a flight recently, and the person who I was sitting next to asked, "What do you do?" And I said, "I represent HOAs." And I'm always a little wary of saying that while I'm going to be sitting next to somebody for 3 hours, because if they've had a bad experience with their HOA, it might not be a good use of our time. But this person happened to work closely with her HOA, and she talked about how she had had a political sign out during the recent election, and her HOA told her to take it down because it wasn't acceptable. Well, she found that law that was applicable. She copied it, sent it off to the board and to the architectural committee, helped to educate them and push back on that that attempt at enforcement, and found it to be effective. So I thought that was a good, success story in an HOA, and maybe you can achieve that too, Leslie.
I mean, ultimately, you could always have the owners that are in favor of fire hardened materials hire. I won't say his name. I won't say his name.
You've already said it. You've already opened the door
Or hire
there.
somebody
Yeah.
that does, Suzanne sits on one side of the HOA things because she represents a lot of HOAs, but I know other attorneys that sit on the homeowner side of that fence. And there's a bunch of them that are very good at helping educate HOAs. What I sometimes find is that the HOAs may not take it up to their attorney, some of these legal issues, because they just don't want to pay the expense of having Suzanne look something over. I'm not, I don't know about Suzanne's communities.
Yeah.
I'm just saying some do that. And so having an attorney letter say that we're going to file suit under Kiowa if you don't do this or whatever forces the HOA to send it up to their attorney, and that might increase the education opportunity for the HOA.
Yep, that's right. And Damian does have references for you if you need somebody who can do that. What else do we have on questions?
Okay, Eric asks, are there state requirements for liability insurance for an HOA with only detached single-family homes, but with a pool?
There's the requirement that liability insurance be maintained in any association that was formed on July 1st, 1992 or after. So it's interesting that the insurance provisions of Kiowa don't apply to communities that were formed prior to July 1st of 1992. They give guidance, but they're not directly applicable under the statute. So usually those insurance requirements are written into the declaration or CC&Rs, and there's so that's where you can find some more specific guidance. And then there's the state statute. It's section 313 of Kiowa that requires the community to maintain liability insurance for common elements.
And I see Aaron has pointed out that the loss assessment
Yeah.
coverage is already changing. So thanks, Aaron.
I'm seeing, so a lot of communities that I represent that have that need for loss assessment are recommending that owners just ratchet it up all the way up to 50,000 if they can, but not all carriers provide up to 50,000 in coverage. I haven't seen anything above 50,000 yet, and I don't know that I will. That, given that how
it might be coming
cheap
down.
that, I know it might come down. It's very cheap, and it didn't used to go up that high. So I think there will be a pendulum swing on that. Okay, and then there's this fair access to insurance requirements plan.
I think that's coming from DOI, right?
Yeah, yep. Yeah, and there
So,
have been some changes to the insurance statutes over the past couple of years. The Marshall Fire did result in some changes to insurance coverage, especially around the alternate living expenses and how long that coverage is supposed to extend if somebody's displaced from their home. So. Okay.
See, then Deborah says if an HOA notifies current owners of a loss, pending assessment, etc., but the owner does not disclose that to a potential buyer, who is responsible for that non-disclosure, the seller or the HOA?
I'm gonna go with the owner. I think the owner has the biggest liability here.
Yeah, if the HOA has already notified the owners, then the HOA, I mean, the HOA doesn't have specific disclosure requirements in a real estate transaction. There are disclosures that are supposed to be provided, but the HOA isn't a party to that real estate contract. So, in that case, if the owner knows about it and doesn't disclose, then
It
I
seems
don't,
like that one's on the owner.
yeah.
And then Eric asks, is there a minimum dollar amount in the statute?
For what specifically, Eric? I don't know.
I don't know what we're talking about. I know
Yeah,
we
I'm
answered
not
a question
sure.
this before, but I don't know what.
Yeah, there's no minimum loss assessment coverage that's specific to communities. There's, yeah, I'm not sure. Liability
Liability
insurance. I don't think there is under state statute, but gosh, I don't see anything less than $1 million, and that's, that gets eaten up very quickly in today's world. So a lot of communities will have umbrella policies, and I think it's really important to talk with the insurance agent on those pieces to make sure you not only have the proper limits, but all of the required coverages too, for things like pools.
Perfect.
So.
Well, I think we'll wrap things up there. Suzanne, we can't thank you enough for giving us an hour of your time. That was super helpful, great information. Thank you, everybody, for joining and for all your great questions. And we will look forward to seeing you in 2025 for another year of industry updates. So thank you so much again, Suzanne. We really, really appreciate you and your time and your expertise today.
Thanks, everyone.
Thanks, Suzanne.
Thank you.
See you
Bye.
next year.